Hi, and thanks for showing up and setting aside some time to watch our webinar on estate planning. If you're watching this, you likely missed our webinar on October 17th at John Abbott College. If you signed up and couldn't make it, you still deserve to learn about this interesting topic. So sit down, relax, have a cup of coffee, and let's talk about estate planning. The first thing I wanted to go and discuss about was what is estate planning? All right, so if we go ahead and look at this, I'm certain many of you already recognize what this mountain is. And yes, it is Mount Everest, the highest peak on Earth above sea level. About 100 years ago, two gentlemen, Andrew Irving and George Mallory, did try to climb the mountain, and they did die, unfortunately. And this is largely due to the fact that, yes, we know they were the first, so the expectations weren't high that they would make it. But also, there were numerous things when it came to trying to explain why they failed. They did die there on that mountain, so we couldn't ask them what happened. Now, about a few years ago, we did discover George Mallory's body in the melting glaciers there in the Himalayas on the mountain, and they found that his goggles that protect you from snow blindness, those goggles were actually in his pocket. It's assumed they died of freezing at night. They may have made it to the summit, but they made it too late. The vast majority of deaths that have occurred at Everest have occurred on the way back down, and this is often because people just wanted to make it to the top, even if it meant making it too late in the day and not having enough time before the extreme cold starts to set in. And a lot of things when it comes to the world of financial planning, which does include estate planning, is all about, making it not just to the goal, but also making it back down the mountain. 30 years later, Sir Edmund Hillary and Sherpa guide Tenzing Norgay finally make it to the top. And if you notice a big difference, it's because Tenzing Norgay is not from England, whereas Sir Edmund Hillary is. Tenzing Norgay he's what we call a Sherpa. Sherpas are highly trained, specialized, and local. They know the area, they know the weather, they know the hazards, and they act as guides. They act as assistants to get you to the summit. Well, with that, I want to introduce myself. I'm Carlo Via with Delta Financial Analytics in partnership with the Retirement Helper Canada. I educate people about topics in financial planning that involves estate planning. We have a lot of training. We have a lot of experience and technology. Yes, we have technology that can help you make better decisions and planning for the future. This presentation is broken down into three main parts, and the first one is celebrity mistakes. These include the stories of Prince and Barry White and Dungeons and Dragons. Yes, I know that's not a celebrity, but it's an interesting story I think that everyone needs to hear. Then we'll go into estate planning myths and facts. A lot of myths about estate planning paralyze us in terms of what estate planning is. And last but not least, we'll go into what estate planning done right looks like. And there we'll go ahead and start this conversation. So let's look at Prince. I'm sure all of you have heard of him. He was probably one of the most talented artists of our generation. He died at 57. I think that's a little too young for such a wonderful star. And he had no will. And worst of all, his six heirs, that according to the state where he died, in Michigan or Minnesota, his six heirs couldn't agree on how to divide the estate valued at $157 million. It took 6 years of legal battles before any agreement was made in 2022. Now, I know what you're thinking. My kids, they're not like that. They're going to be very, loving and not greedy. These litigations really have anything to do with greed. They often have to do with dealing with pain. He died at 57, probably without saying goodbye and giving closure to his heirs. We should not judge and not also expect that our kids are the exception to the rule. We should think of them as humans who deal with pain. And that's why, that's why estate planning is very important. Now we'll look at another case. This is Barry White. I think all of you have heard of him. He was an artist, an R&B artist, big in the disco age as well, and he also died at the age of 58, right? That's very young as well for someone to pass away. And he did have a will, unlike Prince, but he lived separated from his actual wife, never got divorced, and lived with a common law spouse. He cohabitated with someone and when he passed away, but he did not update his will to include that common law spouse and his 9 children. In the end, his wife was his sole inheritor. That's something to be worried about. Just because you have a will, that doesn't mean that that will may be up to date with your current life, right? So we should always take time to periodically review our documents, our estate plan as our life changes. Even if we still remain married to the same person, we don't have more kids or anything like that, our priorities change. So always we got to look at updating our wills. Now, the last story is Dungeons and Dragons, and there, one of the co-founders, barely a year or two into creating Dungeons and Dragons, passed away at 36 from cardiac arrest. He suffered a heart condition, but never did the estate planning to watch out for this. And so his surviving spouse did inherit his shares, and she had no interest in dealing with this gaming business, this board gaming business. Oh, so if I remember correctly, there was a story where Gary Gygax, a co-founder, had said that his spouse just showed up to his lawn and just dropped off all his business partners' stuff related to the board games and was like, here's all his stuff, you deal with it. Anyways, a big problem with this is that they had no money in order to buy the shares from his surviving spouse. They had to find another business partner, an outside investor, to purchase those shares and become a new partner. This led to future conflicts, and the company that created Dungeons and Dragons almost went bankrupt due to litigation among the new investors. So this is something to remember, is that also your business is involved in the estate planning. So let's go into facts and myths. The first myth we're going to go into is your family member or friends are the best choices to become your executor. That may sound correct. I know some of you, most of us, have probably selected our best friend or our brother, sister, father, wife, husband to be our executor. In truth, it's a huge responsibility. My apologies on this slide. It is a huge responsibility to be an executor, or as we say in Quebec, a liquidator. And here's just a overview of some of the general duties. Whoa, that's a lot of duties, right? That's just when it's a very basic case. This can take months, if not years, especially if there's differences of opinion, especially if there is no will, if the will hasn't been updated or isn't specific on certain things, this can be a problem. Now, that's not even mentioning if you have creditors pending, if you have a business and other family issues, it can be a real burden that really does weigh against you, right? Now, when designating an executor, a liquidator here in Quebec, as we say, I like to call this the Indiana Jones and the Last Crusade rule. What does anyone remember what he said? I think he said, choose wisely, right? Oh, I had a call. Choose wisely when choosing a liquidator and executor. Now, let's go to the next myth. That myth is, my common law spouse is automatically an inheritor. This is a huge myth because the fact is, nope. He or she is not automatically an inheritor. We're going to go into why that is. A few key facts about common law, or as we say in Quebec, de facto relationships. Quebec actually has half of all common law relationships in Canada. Second, 42% of all couples in Quebec are common law relationships. That's the highest in the world. If we compare this to France, for example, France is around 18%. And this is a huge growth considering where it was back in like 1980, which was at 8%. We've changed as a society, but our laws have not. Half of all Quebecers believe common law relationships have the same protections as married couples. This is why talking about common law relationships is important in estate planning. You do not have the same protections as married couples. We like to think of this as being true, and that's because a lot of the Income Tax Act in Canada and Quebec often recognizes common law spouses for, benefits, for Canada child benefits, social assistance, disability benefits, etc., but not in terms of family patrimony. And that actually is why a common law spouse does not automatically have a right to your estate. I know some of you are like, well, I'm not a common law spouse. I'm not married. I'm divorced or separated, but I don't have a common law spouse. There's no true definition of a common law spouse. Courts decide on a case-by-case basis, and that's decided often based off of, your shelter. Do you cohabitate under the same roof? Even if not, that doesn't mean you are not in a common law relationship. Conjugal relations, social activities. Do you see family and friends often? How does your community, neighbors, friends, family perceive you and this person? Do they perceive you as being in a relationship? And then habits. Do you cook and clean together? It's not a clear and dry process. There have been cases in Quebec where common law spouses were determined as such, even though they did not cohabitate. They didn't share the same roof. You need to understand this. And just to hammer it again, a surviving common law spouse does not automatically have a right to inheritance unless listed as a co-owner on a common asset. Simple. You need a will. There's no way around that. You need to write one. If not, you do risk the fact of exposing your loved ones to being destitute, kicked out of their home they shared with you. Be wise in this respect. Another myth to tackle is probate is expensive and we should avoid it. This is a myth because in Quebec, probate is a will, or the absence of a will, but it verifies the estate. So let's talk a little bit about where this myth kind of comes from. So we live in Quebec, and this is problematic because we get a lot of our information on personal finance from blogs and documentaries and YouTube videos and Twitter, etc., from places in the US, from Anglo-Canada, but a lot of these do not apply to Quebec or certain provinces and territories. Quebec is not just a language minority because French is the accepted language, but also a legal minority. We're probably the only one in North America that operates under the Civil Code, and the Civil Code, I believe, may also exist in Louisiana for reasons that are obviously we have a common ancestor, which is French. So in other provinces outside of Quebec, probate does exist. It is often viewed as problematic because it charges a percentage based off of total assets, both in the same province and often in other provinces. In Ontario, one of the higher percentages is 1.5% of your assets north of $50,000. Here in Quebec, though, that doesn't exist. Here, instead, probate, yes, does exist, but the fees are not those based off of percentage. It's just the filing fees and whatever legal fees you may need to pay, like if you use a lawyer to get your estate probated. So it is not a big deal. Oftentimes, the recommendations I've seen in many of these websites, books, advisors, etc., and many advisors even here get it wrong, is that you don't need to buy cash value life insurance. So what is cash value life insurance? There's different types of permanent insurance like universal life insurance or whole life insurance. These are not so necessary in order to escape probate. The reason why often they recommend them is because cash value life insurance is an insurance product. When you pass away, it pays out a benefit, typically tax-free, to the beneficiaries. So oftentimes people do this in order to avoid probate because it won't be counted under probate. However, it is expensive to insure both you, who will eventually die, hence why they call it permanent insurance, because they are insuring something that will happen, not something that might happen. Building up the investments inside of that cash value, that portion that is called cash value, is also kind of opaque. It's not 100% transparent, and the costs are passed on to you in the form of a premium. That premium may be very expensive because you're paying for the cost of insuring yourself and the investment portion. Next, this is similar to cash value life insurance, and that is segregated funds. Segregated funds operate very similarly to mutual funds. They're almost the same thing. The difference is that it's written as an insurance contract. It has certain features that mutual funds do not have, and those are guarantees on the value after a certain amount of time. Transferred, these are costs transferred onto you in the form of a expense ratio. So you are paying fees, you just don't know it. They are taken from the investment. They pay out to a beneficiary, just like cash value life insurance. When they pay out to a beneficiary, they are also tax-free. Problem is, as I explained earlier, these are seen in the expense ratio, also known as an MER. And the MER is something that is the fees you pay to maintain your investment to not just the advisor, but also to the financial institution. MERs are typically north of 2 to 3%. You are paying a lot for something that you could avoid by keeping your investment in a mutual fund or ETFs. It is not worth the cost to avoid probate. And the last one is the creation of joint accounts. This one does not apply to Quebec. However, people get it wrong oftentimes. And the logic behind it is, let's say you have non-registered account. You can go ahead and have a co-owner, joint owner on there, and you put your spouse. Now, it would avoid probate if your spouse is the joint owner, and then should you pass away, your spouse would continue being the joint owner of that account. It only applies to the spouse, and this is outside of Quebec. It only applies to spouse and not just to anyone. And I've seen this happen where they name, for example, an adult child, and what happens is that the adult child gets it rolled over. However, there is a deemed disposition in this case because it's not a spouse. So in the end, like I said, no whole life insurance is needed. I can't say that as a blanket statement for everyone. It is a case-by-case scenario, but rarely needed. How do you avoid probate? With a notarial will. In Quebec, the best one and cheapest one and easiest thing to do is just get a notarial will. This is a will written by a notary, and then it is filed when you pass away. Your executor, your liquidator here in Quebec, would essentially go contact the Chambre de Notaire and request your will. It will not be subject to probate, and you can save a lot of time and hassle compared to all these other alternatives like cash value life insurance or seg funds. A notarial will is just a one-time fee with hiring a notary. I would say this is the easiest way to do it. I believe this is our last myth, and that is estate planning is only for when I die. Estate planning, you die and that's it. No, it's when you become incapacitated. A will only works when you die, but a mandate, known as a power of attorney, works when you become medically incapacitated. So you are not able to communicate and you are not able to, let's say, go to the bank and do something that you would otherwise do in person. So for that's why we have mandataries. A mandate is essentially composed of mandataries, and you can get one mandate written out by a notary, also included in the same action as you would while writing your will. And in that, you can communicate who you want in charge of your business affairs, your financial affairs. You could divide it among different people. and your medical decisions. The financial side of a mandate, also called a protection order, must be filed with the court. Even though they're written, you must also take them to court to be filed and approved. That's it. And it's a relatively quick process. If you didn't have a mandate, let's say you're incapacitated and your loved one, it can be your spouse, goes to court and requests the mandate, requests to have essentially powers of attorney over you in certain cases, you are up to the whims of the judge. You should also choose a mandatory, and they should also be a resident of both the country in which your assets are located and the province or state. And here's why I say state. Let's say snowbirds reside in Canada, but spend part of the year in places like Florida, California, Arizona, more mild climates during the winter. And so if, let's say, you have a home, a condo in Florida, and you become medically incapacitated in Canada, your mandatory should not be a Canadian. Your mandatory should be someone residing nearby in the state in which your asset is located in order to ensure that they can handle their affairs in your absence. Lastly, you should also be specific into what they can do. If you have one person is competent in helping run your business, they should have a mandate with the affairs of your business, and another should have a mandate with your personal financial affairs. So this is something important. By limiting the scope, you can ensure that they carry out the best duties within one domain, and they're not going to be overworked, and two, they also can't do anything fishy in the other areas. So in terms of healthcare mandates, these only apply to decisions that have to do with life and death. So they can prolong your life or cut it short. A certain medical treatment that may be invasive, that may be very difficult on you, they may have to choose for you if that is something worth doing in order to extend your life. These are not legally binding in Quebec, but they give them the guidance to make the right choice that you would have made. And you can't hold that against them if they don't, but at the very least, they should follow your expressed desires in a life or death scenario. These will only become effective upon mental incapacity. They don't need to be filed with a court. This is one of the simpler ones, but you need to be careful. And here are some considerations when choosing, designating a mandatory. You should consider compensating your mandatories. If you own a business, you should pay someone to be your mandatory while you are absent from managing it. That is, if you're the business owner, it can be a full-time job. Paying someone to set aside their own personal and professional life to help manage your business and make decisions, they need to be compensated. Another is hiring professional mandatories. There are businesses that do trusts and other financial and legal transactions. They have people who can serve in your absence that you do pay. This can be paid typically through certain insurance policies like key person insurance, critical illness, and disability. We can explore that if you're interested. That can cover on a tax-free basis the compensation for a professional mandatory. Update your mandate upon any material changes in your life. Another child, you have a new business, you close an old business, you have a new partner, or you separated or divorced. And the reason why is because these do not update automatically. They do not become voided after a divorce or a separation. Lastly, you could also choose to designate a monitor. So a monitor is like having a counterparty to ensure that your mandatory is taking the correct action, that they're not spending too much money on certain things or not making decisions that make no sense. The monitor can help supervise the mandatory. And what's interesting about this is, let's say you have 5 children and you designate 2 children for financial and business matters and 2 children for medical matters, and you have a 5th one. What are you going to do? Well, you can appoint them to be a monitor. This is an interesting alternative to reward or burden your children or family members with your mandate. A mandatory has a fiduciary duty. Fiduciary means someone who is looking out for your best interest. They can be challenged on that, but they have to act in your best interest. It can't just be seen as taking decisions that make no sense. Now, when designating a mandatory, there is the famous Indiana Jones rule that is to choose wisely. You got to choose wisely because it can be a lot of work. Let's go to the last phase of our presentation, estate planning done right. The Delta approach is process before product. Estate planning is one aspect of good personal financial planning, even for business owners. There are more pieces to this than just estate planning. Estate planning is one aspect of financial planning. A friend of mine, Preet Banerjee, calls this comprehensive financial confidence, and it is several dimensions, right? So we got to look at risk planning, cash flow, retirement, education, estate. These are all aspects of having good financial health. And so one way you can evaluate your financial health is by taking our Money Gaps questionnaire. It's a financial snapshot, takes 2 minutes, and it's a series of yes or no questions. You'll get a PDF report that says, what should you kind of work on. Now, you can get that by scanning the QR code you see below me, or for some of you who may have my business card, you can also scan it there too. And we have an approach that involves the hierarchy of needs. So Maslow created a hierarchy of needs, oftentimes reflected as a pyramid, though he never said pyramid. And that is cash flow management first. So we have to first ensure our biological needs, air, water, food. That's managing cash flow and debt. That is making sure that we survive the day to day. Then you have safety and community. And this, I like to look at it as risk planning. So you got to make sure that should something happen to you during your working years, everyone around you is taken care of. Then we have tax planning. We also have esteem and status. And this is more for retirement, doing these more abstract things that we want, making sure kids go to the right schools. Lastly is self-actualization, which is estate planning. So you want to be remembered as. Everything begins with an elements evaluation. This is kind of a really cool tool available through your phone. It's like going to your doctor and they take your blood pressure, they take, samples, and they see how your overall health is doing. Are there red flags we need to take care ASAP? That's the first evaluation, usually by booking a 15-minute meeting with me. It is free, and at the very least, you could have an understanding of where you are today. Now, let's go ahead and look at the next slide. We got to create a baseline for where you are today and where you're going tomorrow. That's usually through financial planning software. I use one called Conquest Planning. It's user-friendly and visual. Then we got to see, okay, well, where in the future, according to how you've expressed what you want to do in the future, are we able to finance that, to fund that? And if we see holes, like here we see it in red, what can we do in order to fix that? And this comes into different, evaluating different strategies. And so what we do is we use our Conquest Planning platform. It has a really cool tool that allows us to look at your situation and test different strategies. Do we save more today? Do we make more money today? Do we spend less in retirement? Do we downsize your home? These are all questions that depend on you to help answer. And that's why when we do discovery meetings, we talk about your values. What's important to you? Where do you come from? What do you want to leave behind your children? If you have an emotional attachment to your home and you want your children to inherit that, then telling you to downsize may not be the best thing for you. And the other question that goes into this is money is fungible. So money can be put in one thing or another. It can be spent today, saved, and given tomorrow. Because it's finite, we need to think about what are your priorities. Is it your retirement? Is it your quality of life or legacy? Do you want to pass as much as possible to the next generation? I call this team retirement or team legacy. And it all depends on you. We need to look into what happens when life happens. If you're seeing me today, chances are you are not going to die today, right? I mean, hope not. But we still need to see what happens if different things happen. So if you get hurt, incapacitated, or you die, what will happen to your family, your business, your pets? They need a loving, caring home even after you're gone. And so we also then have to look at what are the risks that can cause that. So we have death, disability, incapacitation, and they all each have different percentages. Like death, for example, the risk of dying is influenced by your gender. Are you a smoker? Certain professions have higher mortality rates than others. And this needs to be looked at. And then let's say it's a very, if let's say you're barely 55, the chances of you dying is extremely minimal. It's very low. Insuring you could be low cost. But if you get disabled, that also can be influenced by gender, profession, age, etc. And that cost is higher because the probability of it is much, much higher than death. So I'll give you an example. Here in Canada, we know that working aged Canadians have a 30% chance of disability, and that's defined as an absence from work for more than 90 days. If it's a 30% chance, whereas the chance of dying before 65 is 3 to 4%, that's going to cost more dollar for dollar. But it may be worth insuring against. We have to measure the consequences and if it's worth the costs. What is the risk? What is the probability of it occurring? What is the potential cost of it from when it occurs? And if the cost of insuring against it is worth it. These are things we need to look at. Now, I just wanted to go into this last step and mention it to you. But after we've looked at what are the ways or the things that can happen to you, then we can go ahead and see what are the insurance needs, if necessary, and what estate planning documents, what are the different clauses that need to be written into them. Now let's look at drafting your documents. So there are questions we formulate to create the best estate plan for you. One question is, do you have or do you want kids? Let's say you don't have kids, but you want kids. We can ask the notary or the lawyer to write a will that mentions a child of a specific spouse, a child existing or a child to be born yet, that they can be included in the will. This helps protect you, your children, and your spouse. What is your present relationship? Are you in a common law couple or are you married? Is it a civil union? Is it a cohabitation agreement? These can help us also make sure that they're covered in the will if that is your desire, or excluded from it. We're not judging anyone here. So these are important questions to ask. And another one is, where are your assets located? Like I explained with the mandatory issue, if you have assets in another country, in another province, you need to have someone in that province to help you. Are you a business owner? This is important. Death, disability, and divorce have big consequences for business owners, and we need to have the right plan and contingencies in place should something happen to you. Do you want to donate? Charity is important. You can use existing policies as donations when you die. Allocate a portion of your insurance policy, transfer assets to charities, but also this helps you become more tax efficient when your estate needs to be liquidated. And then another very important one. Do you want to give assets now? If you have adult children, you want them to own a home. It is very expensive now. You can gift them assets now before you pass away. There's a difference between helping your child buy a home now and 40 years from now when you pass away at 90. Then there are questions specific to your situation. Do you have a disabled child? This means that we would have to make sure that in your will you have what we call a testamentary trust. And these trusts come into effect after you pass away and can be converted to a qualified disability trust, meaning that they're no longer taxed at the same rate as a regular trust. And they also can prevent your child from being from having their benefits clawed back now that they've inherited your estate, by having a Henson Trust and ensuring trustees are in charge of those assets instead of your child and for their benefit. So that way, now the child won't have social assistance payments clawed back because they have so much of your estate inherited in their name. Next, we also have business partnerships. We need to know, do those exist? We need to, those will also involve certain recommendations like a buy-sell agreement, shareholder agreement. And these are all contingencies in case one of you gets disabled or pass away, to make sure that there is continuity in the business. I would say another one that's important is cross-border estate planning. As I mentioned just earlier, this can cause problems. Your liquidator should exist in different provinces and states wherever your assets are. If an American is your liquidator in Quebec, that will cause tax issues. Make sure you have your bases covered on both sides of the border. Please book a one-on-one. It's free, only 15 minutes, and we'll give you information that is specific to your needs. Remember, you can always just scan it on the business card or below in the webinar. Now, let's think about your options for drafting an estate plan. So now working with an advisor helps you if the advisor, of course, is proactive in answering these questions. Many of them are not. They just think they do mutual funds or pick stocks for you or sell insurance. And if you're here, you're watching this webinar, chances are you are not dealing with someone who cares about your estate plan. So there are different options when it comes to drafting those documents, and that is book a meeting with a notary. You can be recommended one. You can go shop around. I would take 10 minutes to ask your family, friends, or your advisor. You can go ahead and just literally call any of them. Talk with them, ask them about your particular situation and how they would handle it, because each one is very different. Notaries can help you avoid probate in Quebec with a notarial will. Remember that this is a very transactional relationship. You are paying only for this kind of, this document. Once written, that relationship doesn't exist. You need your situation kind of mapped out either on a piece of paper, either from a document that, let's say, your wonderful advisor put together for you that says all your concerns and what should be in the will. They're going to get paid the same amount for your will. They're incentivized to do the less work possible. So they may not ask about all these little questions. So you got to be wary about that. Next one is DIY options. These exist. There are will kits on Amazon. You could go to a bookstore and get them. Unless you have a very, very simple situation, these are things that I would avoid, because if you have a business, if you have complex situations, as I mentioned, let's say common law relationships, etc., a will kit can be a cause for problem. They still need to be probated, but at the very least, it's better than not having a will at all. Then there are options like Clear Estate. Clear Estate is a one-stop shop where they give you a portal, access to a notary, do your powers of attorney, your mandate, your will, and through the portal you can map out where everything is going and specific instructions for whoever your chosen liquidator will be. Your advisor can help as well. I do have a referral relationship with them. They do not pay me, but they do give 10% discount to anyone I refer to their service. It is not the cheapest option out of these three. However, it is the most comprehensive option. So give them a look and let me know. Now remember, in the end, this is your greatest threat. You procrastinating. It's normal. We're human. I procrastinate all the time when it comes to things, and my wife hates me for it. But procrastination is your biggest enemy when it comes to estate planning. None of this information I'm giving you is going to matter if you do not act on it. Remember, procrastination is your biggest enemy. What happens when you die without a will? So, as I said, let's say you procrastinate, this happens. your loved ones or you should go to Educalois. I highly recommend it. They have French and English portals, and you can ask all kinds of questions, and there they have all kinds of answers that are pertinent to the Quebec resident. So this is an awesome resource. And there they actually have a really good chart in PDF where you can look at your specific situation and follow down the chain according to the answers, the yes or no answers that you provide. And it would say what happens when you pass away without a will. This is excellent because then if you don't like the answer, then you will definitely need a will. I don't think you have any excuse. If you've attended this meeting and this webinar and you are watching me speak and you are getting all this information, you have no excuse to not have a will. It is clearly affordable. It is clearly something that you should act on. But again, I'm not your boss. I can only give you guidance. I can't do it for you. Here are 3 steps to avoid an estate planning mistake. First, book a 15-minute virtual coffee with me. It's free. It can go more than 15 minutes, but that way we just answer any questions and point you in the right direction. If you have more and more questions, we can schedule other meetings for that too. You'll also get to ask questions specific to your situation, and we will give you information specific, unique to you, what you need, because we don't have all the time in the world to go over it here. So this is a preferred method if you have a situation that you feel needs to be addressed in private on a one-on-one. And then also at the end of it, you'll get a Elements action plan. This is a 1-page plan. It says the diagnosis of your situation and the treatment. It can be 3 steps of what you can do to improve. This is free. It takes 15 minutes of your time, and you will get this at the end. For some of you who may have questions, I will be available. You can reach out to me via email, or you can scan the QR code below here, and there you can book a meeting with me. Take care, and I wish you a wonderful day.